The first letter arrived on a Tuesday morning in March, slipped through my mail slot like a snake entering a henhouse. I was still in my bathrobe, coffee in hand, when I picked up the thick cream-colored envelope embossed with the Willowbrook Estates HOA logo. Notice of violation number 1. It read in bold, aggressive font, "Unauthorized fence installation. You have 14 days to remove the structure or face fines of $100 per day." I stared at the letter, my hands trembling slightly. The fence they were referring to was a simple 4-foot wire mesh barrier I'd installed around my vegetable garden in the backyard, my own backyard, to keep the neighborhood deer from destroying the tomatoes and peppers I'd spent 2 months nurturing. I'd checked the HOA covenants 3 times before installing it. Nowhere did it say I couldn't have a garden fence in my rear yard, behind the privacy fence that already existed. I called the HOA management office that afternoon. A bored-sounding receptionist transferred me twice before I finally reached someone who identified herself as Patricia Hendricks, the newly appointed HOA president. "Ms. Hendricks, I'm calling about this violation notice. I believe there's been a mistake. My garden fence is—" "There's no mistake, Mr. Morrison." Her voice was clipped cold, with an edge that suggested she'd been waiting for this call. Section 4.7 of the covenants clearly states that all exterior structures require board approval, but it's behind my privacy fence. You can't even see it from the street. Irrelevant. The covenant says all structures. You failed to submit an application. The fence comes down or you pay the fine. Those are your options. I spent that evening rereading every page of the HOA documents I received when I purchased the house 2 years earlier. Section 4.7 mentioned visible structures and streetscape aesthetics. My garden fence was neither visible nor affecting any streetscape, but Patricia Hendricks didn't care about logic. The fines started accumulating. Day 15 arrived, and so did another letter, $100 fine. Then another, and another. I submitted a formal appeal, complete with photographs showing the fence was completely invisible from any public area, citations from a covenant language, and a detailed argument about reasonable interpretation of HOA rules. The appeal was denied in a 3-sentence letter. By late April, I owed $4,500 in fines. I'd removed the garden fence by then, watching the deer destroy my plants that same night, but Patricia had discovered new violations. My mailbox was apparently the wrong shade of black. My lawn was mowed in the wrong direction. My recycling bins were visible from the street for 45 minutes past the allowed time on a Wednesday morning. Each violation came with the same mechanical process. Notice, rejection of appeal, fines. I began researching Patricia Hendricks. What I found made my blood run cold. She'd moved into Willowbrook Estates 8 months earlier and had immediately run for HOA president on a platform of restoring community standards. In the 6 months since her election, foreclosure proceedings had been initiated against 4 homeowners. 3 had already lost their homes, sold at auction for a fraction of their value to cover HOA fines and legal fees. The houses had all been purchased by the same LLC, an entity that, after some digging through public records, I discovered was partially owned by Patricia's husband. I was being targeted. This wasn't about covenants or community standards. This was a shakedown. In June, I received a letter I'd been dreading, notice of intent to foreclose. My accumulated fines, late fees, and administrative costs now totaled $23,000. I had 30 days to pay in full or enter a payment plan that would effectively double the amount, or the HOA would place a lien on my home and begin foreclosure proceedings. I couldn't afford $23,000. My savings had been depleted by my mother's medical bills the previous year. A payment plan was financial suicide. I was trapped exactly as Patricia had intended. That's when I decided to fight back. I spent 2 weeks consulting with attorneys, including a property rights specialist named Rebecca Torres who'd handled HOA abuse cases before. Her advice was simple but expensive. You'll need to sue them. It'll cost you up front, but if the pattern is as clear as you're describing, you'll win, and they'll pay your legal fees. What do I do in the meantime? I asked. Rebecca smiled grimly. Make them regret targeting you. Legally, of course. I began my research. The HOA covenants had a loophole the size of a semi-truck. They prohibited fences visible from public streets or neighboring properties, but said nothing about security systems. And in Colorado, where I lived, property owners had broad rights to protect their land from wildlife and trespassers. I called a security company that specialized in agricultural fencing. I need something that'll keep deer out, but won't actually hurt them. I explained. High voltage, low amperage. Completely legal and humane. 3 days later, a crew arrived and installed a professional electric fence system around my entire backyard perimeter, inside my existing privacy fence. The system ran at 10,000 volts, but less than 1 joule of energy, enough to deliver a shocking surprise to anything that touched it, but incapable of causing injury. Signs were posted every 10 feet. Warning, electric fence. It was completely legal, completely within code, and absolutely not covered by any HOA covenant. Patricia's letter arrived within 48 hours. This one was delivered by certified mail. Emergency violation. Unauthorized security system. Immediate removal required. Fine, $500 per day. I didn't remove it. I documented everything instead. Every letter, every fine, every threat. Rebecca began preparing our lawsuit. The fines escalated. Patricia sent letters threatening criminal charges for booby-trapping my property. She called the police, who came out, inspected the fence, and told her it was perfectly legal and clearly marked. She contacted code enforcement, who found no violations. She even tried to claim the electric fence was a public nuisance, though it was on my private property and clearly worn with signage. By August, my fines had reached $67,000. In September, the HOA filed foreclosure paperwork. That's when Rebecca filed our lawsuit. We sued Patricia Hendricks personally, the HOA board, and the management company for selective enforcement, abuse of power, fraud, and civil conspiracy. Our evidence was devastating. Documents showing Patricia's husband's LLC had purchased the 3 foreclosed homes for pennies on the dollar. Email records we'd obtained through discoveries showing Patricia targeting specific homeowners with the best property values, and testimony from other residents who'd been similarly harassed. The trial lasted 3 days. Patricia sat rigid in her defendant's chair, her lawyer looking increasingly uncomfortable as witness after witness described her systematic campaign of targeting and intimidation. The jury deliberated for less than 4 hours. They found in my favor on every count. The judgment was brutal. $125,000 in compensatory damages, $60,000 in punitive damages against Patricia personally and full attorney's fees, another $48,000. The HOA was ordered to void all fines against me, remove Patricia from the board immediately, and implement oversight procedures to prevent future abuse. Total judgment against Patricia, $185,000. But here's the beautiful part. Because Patricia had been acting in her capacity as HOA president during her scheme, and because the HOA's insurance refused to cover intentional fraud, Patricia was personally responsible for the entire amount. The 3 foreclosed homes were ordered returned to their original owners at the prices they'd been forced to sell them for, plus damages. Patricia filed for bankruptcy within 2 months. Her husband's LLC dissolved. They moved out of Willowbrook Estates in the middle of the night, leaving their own home to foreclosure. I'm still in my house. My garden is thriving, protected by its perfectly legal electric fence. And every time I harvest tomatoes, I think about Patricia's face when the verdict was read. The HOA has new leadership now, reasonable people who understand that covenants exist to maintain property values, not to destroy them. We've even revised the rules to prevent what Patricia did from ever happening again. Sometimes, when you're backed into a corner, the best defense is a good offense, and maybe a 10,000-volt fence.